Welcome everybody to Excel's Civil Enforcement's webinar on the use of High Court enforcement within local authorities. Before I start the technical talk, can everyone just let me know that they can hear me? If you can type yes into the questions box, that would be great, please. Brilliant, we've got quite a few yeses there, that's great. So just starting with the technical tour. Just waiting for the slides to move on. Bear with us just a second, we're having a bit of a technical issue at this end. Okay, so hopefully you can all see that now. The webinar dashboard can be minimised or maximised by clicking the white arrow in the orange box. Hopefully you can all see that. And you're more than welcome to ask us questions throughout the webinar. Obviously, we'll try and address them as we do go along, but if we don't, then we'll address them at the end or we can email you afterwards. So we have to say this at the beginning, so this is our disclaimer. Please treat the contents of the webinar as food for thought, but don't take any action based on its contents unless you have taken independent legal advice. The speakers cannot accept responsibility for any errors or inaccuracies, loss or damage, unless we have given you personally specific advice relating to a matter about which you have given us full background details. You must also bear in mind that the contents of the webinar are based on current English law, and because it contains archival material, the material is bound to go out of date. So first of all, I'd like to introduce our guest speaker today, Alan J. Smith. He's one of the directors here at our parent company, High Court Enforcement Group. Alan's the Director of Corporate Governance and he has over 35 years experience in the enforcement industry. He's also an authorised High Court Enforcement Officer who actually started his career out in local government, so he's well placed for this presentation. Not only did he deal with the general rates, the poll tax, but also council tax. He's worked for the High Court industry since 1993 and he's also the Vice Chair of the High Court Enforcement Officers Association. Hopefully you will remember me from previous webinars, but I'm Laura Ann Smith, the Account and Business Development Manager here at Excel Civil Enforcement. I bring 10 years local government experience of managing finance teams, specialising specifically in revenues and benefits performance management and collection. I have my IRRV tech qualifications, my level 2s in taking control of goods, and I'm the current IRRV Thames Valley President. So kicking off the webinar today, just so we can gauge our audience, I want to start with the first poll. How many of you are already using High Court enforcement as a recovery action? Hopefully you should see the poll launch. So everybody's just answering that. We've got a good split there. Okay, so we've got a few changing their minds. So we've got a divide there of 33% already using High Court enforcement action and 67 who aren't. So hopefully the presentation that we're going to give you today will be useful for everybody. What I'm going to do now is pass over to Alan.
Good afternoon, ladies and gentlemen. And welcome again to this afternoon's webinar. Hopefully you'll find some areas of this of interest to you if you're within the local authority, revenues departments or legal teams. So kicking off, what type of local authority debt can be enforced by a High Court enforcement officer? Well, there are a number of areas that you could look at. You could look at your normal sundry debts, housing benefit overpayments, both fraudulent and non-fraudulent overpayments, former tenant arrears on commercial premises. Council tax can be looked at, not using enforcement agents for taking control of goods, but looking at whether or not you can look at possession orders through orders for sale. And on non-domestic rates, where you've issued a county court claim rather than a liability order, because you do have the option when you issue your reminders under non-domestic rates to decide on which course of action you're going to take, whether you're going to go down the magistrates court route for a liability order or whether you're going to issue a county court claim. So who are you currently using for enforcement of your judgments if you are enforcing any county court judgments? Well, all judgments up to £600 must be enforced by county court bailiffs, so you would have no choice, you would have to use them. However, where your judgment's over £600, you do have a choice. You can use a county court bailiff for judgments up to £5,000, or a High Court enforcement officer where the judgment is over £5,000, but also a High Court officer between £600 and £5,000. But there's some questions you should be asking yourself before considering using a High Court enforcement officer. Is your debtor worth enforcing against? What do you actually know about your debtor? What do you know about any goods that they may have? Is it going to be worth spending the money to go down judgment and ultimately enforcing against them? What's the cost of enforcement going to be as against the value of the debt that you're trying to recover? What type of debtor are you enforcing against? Is it a company, an individual, a partnership? Have you got the right legal entity before you commence your claim through the courts and ultimately your enforcement? Because if you don't get it right at the beginning, it will fail at the end. Do you know the debtor is at the address for enforcement? What have you done in terms of background checks to make sure that you have got a current address for the judgment debtor that you're after? And have you done a final check to make sure whether or not your debtor is solvent or not? So, who are High Court enforcement officers? Well, prior to the 1st of April, if you had used us, you would have known us as under sheriffs or sheriff's officers. But the Courts Act, Clause 99, Schedule 7, received royal assent in 2003, and it introduced a new term of a High Court enforcement officer. And every High Court enforcement officer has to be authorised and is authorised by the Lord Chancellor. So we are private sector enforcement officers, but we are appointed by the Lord Chancellor. And the key point is the authorised officer is responsible for all the actions taken under any writ in his or her name. So we are liable for our enforcement agents and every action that they take when they're enforcing any writs in our name. What regulations do we work under? Well, we operate under the High Court Enforcement Officers regulations, but we then work under all the taking control of goods regulations that came out in 2013 and 2014, together with the Tribunals, Courts and Enforcement Act of 2007. There were some amendments as well to those acts that give us specific powers. So under the Crimes and Courts Act, for example, that gives us the power to break in and enter commercial premises without having permission of the court. And then obviously there are all the other regulations, and obviously the civil procedure rules are key to those regulations, and we operate under those. So in enforcing a money judgment using a High Court enforcement officer, as we said earlier, any judgment over £600 can be enforced as long as it's not a consumer regulated debt, but within local authority there shouldn't be any consumer regulated debt. The standard writ that we would use for enforcement is what we know as a writ of control, a Form 53, and it is equivalent of what is known as a county court warrant. But as I've said as well, any judgment over £5,000 must be enforced by High Court enforcement officers, not by the county court. If you were to use High Court enforcement officers, how much would it cost you to instruct us? Well, the current fee payable is £66 for a court fee to obtain the writ of control. However, where we collect in full, we collect £117.75, what is known as costs of issue, formerly known as costs of execution, which goes back to you, the claimant. And also we will get 8% interest from the date we transfer up the judgment from the County Court to the High Court. If we were unsuccessful, then there is an abortive fee of £75 plus VAT, and High Court enforcement officers will make a minimum of 3 visits. One of those will be an out of hours visit, i.e. 6 in the morning till 8 in the morning, or 6 in the evening till 9 in the evening in terms of residential premises. What could you expect from your High Court enforcement officer? Well, we'd be looking for first-time compliance and early payment of judgment debtors, offering them convenient payment options, so payment using online card payments, telephone IVR payments, direct debit, or payment into the bank account. With a firm but fair approach, working within the regulations and the national standards. We have a proven, experienced, professional and highly trained team with our own training department. We use the latest advances in technology and development using our in-house developers. And we like to work with clients to agreed service levels, so you actually know what you're going to expect from High Court Enforcement Group in terms of enforcement of your judgments. And we like to produce information as much in real time about the progress of writs. So as soon as visits are made, reporting to the client, providing the client with online access so they can see what's happening in respect of their writs. But one of the key areas is protection of client reputation, so treating your customers fairly, making sure that we've got quality management, which we have, ISO 9001, 14001, 7001, and also 18001. All staff and agents are CRB and credit checked. We have a clear complaints procedure, staff non-disclosure and confidentiality agreements, and work with diligence, integrity and honesty, because the client's reputation matters to us as well as our own reputation. We're able to audit trail all our actions under writs that we do, so there's full transparency in all our actions through a full online system which clients can have access to. That system shows full transparency on the fees that we charge the debtor and when the fees were applied, and actually the charges for the fees all under the Taking Control of Goods Fees Regulations 2014.
So now we know a bit more about how High Court enforcement officers work and what regulations that they work under. Just a quick question to everybody. How do we get a judgment from the County Court to the High Court for enforcement? What needs to happen? So we've got some polls ready and set up here for you. Hopefully you're going to see them on your screen. Hopefully you're going to have those options on there. So first option, start a whole new process to obtain a writ in the High Court. Number 2, transfer up. Number 3, wait for the County Court to automatically send it to the High Court. A few people just making up their minds still. Of course, the correct term is transfer up. So we transfer up from the County Court to the High Court. I'm glad to see that pretty much everyone got that right as well. Handing back to you, Alan.
Thank you. So yes, the answer is that we transfer up the judgment from the County Court to the High Court. It's a process that we at High Court Enforcement Group offer to our clients. It's a free process because it is just an administrative process, and we can look after all of that. All we require of clients is a copy of the County Court judgment together with as much information that the client has on their judgment debtor, such as address, telephone number, email addresses. What we then do is we complete what we call the N293A and also prepare the writ of control, and this is sent to the court ideally on day 1, but certainly by day 2. And we have a number of relationships with a number of panel courts around the country, and generally we're getting the writs back within about 48 to 72 hours, but some courts can delay that, so we do allow anything up to 14 days, but we will chase the courts. As soon as the writ is sealed by the district registrar and returned to ourselves and lodged on our system, then we can commence the enforcement process, and the start of that is by the issue of the notice of enforcement. But what does the authority give the High Court Enforcement Officer? Well, it directs the High Court Enforcement Officer to take control and sell the judgment debtor's goods which are sufficient to satisfy the judgment debt, costs and interest and fees of the High Court Enforcement Officer. The High Court Officer is not entitled to break open the outer door of a dwelling house. However, we do have the power to force entry to commercial premises where they are wholly commercial. There are a number of third-party acts that can affect the successful enforcement of a writ of control, such as insolvency and third-party claims. And we're able to enforce a writ of control on any day of the year. And how are we paid as High Court officers? Well, as I've said earlier, we are part of the private sector, but with a responsibility to the courts, and we're answerable to the courts for the fees that we charge. And we charge judgment debtors under the taking control of goods fees, but where we're unable to recover off the debtor, then there will be an abortive charge that we make to the client of £75 plus VAT.
And while we're just talking about the process and the fees of High Court enforcement, just like to ask everybody another question. How many collection stages are there in the High Court enforcement process? Hopefully you can all see that poll launched on your screens now. So we've got 2 stages, 3 stages, 4 stages, or 5 stages. So everybody's just making up their minds. Give everyone a couple of seconds there. So what's the correct answer, Alan?
The correct answer is actually there are 4 stages within High Court enforcement, and we'll now cover what those 4 stages are. So the 4 stages are the compliance stage, which is the issuing of the notice of enforcement stage 1, enforcement stage 2, and a sales stage. And these are prescribed in the Taking Control of Goods Fees Regulations 2014. And unlike the common perception, the fee for compliance stage is triggered on receipt of the instruction, not at the point the notice is sent. So the notice of enforcement informs the debtor that a decision for the enforcement action by taking control of goods has been made. It details the outstanding balance, date payment must be made, and also the fees incurred should payment in full not be made by the date specified. 7-day notice is not inclusive of the date of postage. It allows 2 days for delivery, and we have to exclude Sundays and bank holidays. So generally, we're looking at around about day 12 for the expiry of a notice of enforcement. And in exceptional circumstances, we can make an application to the court to reduce the notice period. And we would have to plead in front of a judge why we want that reduction. So enforcement stage 1 and enforcement stage 2, and we've detailed what the fees are for these. So enforcement stage 1, it is £190, and for High Court enforcement, there is always VAT on top. So that takes it up to £228, and there is 7.5% of any of the judgment debt over £1,000. So where the debtor fails to pay in full during the compliance stage, and a debtor must pay in full during that stage, we are unable to enter into instalment arrangements, and the regulations together with the advisory notes quite clearly state that payment must be made in full. Then an enforcement agent will attend the premises and attempt to take control of goods. If when we attend, the debtor immediately pays in full or agrees to an acceptable instalment arrangement, the fees are capped, and any instalment arrangement should be covered by a controlled goods agreement. However, if we don't make contact with the debtor, or the debtor was to default on a controlled goods agreement, then we would move to enforcement stage 2. And this is a further £495 plus VAT, which will be charged to the debtor. And we can actually move to this stage on first visit if there's a clear refusal by the debtor to enter into any acceptable arrangement or to comply with the request for a controlled goods agreement. And the agent will actually move to this stage at that point. We may move to that stage after we've made a visit, so any further subsequent visits would attract enforcement stage 2. And if we've entered a controlled goods agreement and the debtor subsequently breaches that, then a further attendance will be made and stage 2 will be applied. We do find that some judgment debtors will not comply with a controlled goods agreement, so they may enter into an arrangement but then default. They may not comply on first visit, and we actually have to move all the way through on first visit to what we call sale stage, where we have identified goods that are of value to be removed and possibly then, when sold, bring about payment to the client. So if we move to this stage, there is again an additional fee of £525 plus VAT, £630 in total, and again a further 7.5% for any of the judgment debt over £1,000. If we immobilise a vehicle, we have to give notice under the regulations. Also, if we are attending where we've got a controlled goods agreement, we have to give the judgment debtor notice that we intend to attend the premises to remove the goods that we have listed under the controlled goods agreement. We need to do specific content of the inventory of goods, so the enforcement agent will detail dates and reference numbers, the balance breakdown, the manufacturer, model, serial number and colour of all the goods, an evaluation of goods if required by a qualified independent valuer if we require it. And we hold responsibility for the care of those goods whilst they're under our control after we've removed them. But things to remember after you've issued the writ of control and we are enforcing that writ. If you have any contact with a debtor, refer them to ourselves, the High Court Enforcement Officer. If you become aware of any payment to yourselves after issue, advise us as soon as possible. Do not enter into any payment arrangement with the debtor without first speaking to us. And do not get into any discussion with the debtor without checking with us at what stage of enforcement we are at and where we are, because it could be that our enforcement agent is actually sat with your judgment debtor. And why? Because ultimately you could be held liable for our High Court enforcement fees. And ultimately, as I said before, if we are unsuccessful for High Court enforcement, there is an abortive fee. The regulations that stipulate this are the Tribunals, Courts and Enforcement Act 2007, Consequential Transitional and Saving Provisions Order 2014, that specify that the £75 plus VAT is payable. So that covered writs of control, but how can you use other writs that High Court enforcement officers enforce? So another writ that we do enforce is what we know as a writ of possession, but also a combined writ of control and possession. That's a monetary judgment together with a possession order, and we also enforce compulsory purchase orders. So the types of property for writs of possession could be domestic premises, homeowners and tenants where there's rent arrears. We do shop squats for squatters, travellers on open land, squatters in normal commercial premises, and also environmental protest sites, which is dealt with by our national eviction team, which is part of the group, and they do a number of webinars on that type of work that they undertake. So please do watch out for their webinars. So enforcing a possession order using a High Court Enforcement Officer, what does the writ do? It directs the authorised High Court Enforcement Officer to put the claimant into possession of the buildings or land that's described in the land. And there are two types of writ of possession. There's a straight writ of possession, which is just to give possession, but also what we know as a combined writ of control and possession. And the writ must contain a specific description of the land and buildings, and where it is just land, there normally will be a plan attached to the writ identifying the land. Under a writ of possession, there is no period of grace allowed to a defendant or occupant under a writ of possession. It is one of immediate execution. And the officer is under no obligation to give any warning to the occupants. However, we do find on residential premises, it is better to give that warning because it does make the eviction a lot easier. And there is currently a consultation out from the Ministry of Justice around this area that High Court Enforcement Officers should be looking to give actually notice on residential evictions. For the purpose of the execution, entry can be gained by force, so we are able to use force to enter any premises, and we're entitled to use what we call reasonable force to eject the occupants. However, there is no definition of what is reasonable force. It's what we face on the day from the occupants who may be refusing to leave the property. And the writ extends to the eviction of all persons found upon the premises, but not to the removal of goods and chattels. It is the responsibility of the claimant as well to identify the premises to which the writ relates. But one of the big writs that we like to see used by local authorities is what we call a combined writ of control and possession. And this is getting used quite a bit for council tax liability orders and housing benefit overpayment fraud or sundry debt, where the actual judgment debtor owns their property and it can be enforced by the use of a charging order. That charging order can ultimately be turned into what we call an order for sale, and if an order for sale is granted, a possession order can also be given. It is then possible to convert that possession order into what we call a combined writ of control and possession. For council tax, the process is to bring the liability order across the jurisdiction from the magistrates court to the county court, and this will then create a judgment in the county court. An application is then made for a charging order. Following the charging order and application, a further application can be made for an order for sale. And within that application, the following wording should be inserted to the court that the claimant intends to make an application for leave to have the matter transferred to the High Court pursuant to Section 42 of the County Court Act 1984. Without this permission, it's not possible to enforce in the High Court. You need the permission of the court that it may be transferred to the High Court for purposes of enforcement. We find that this process is very, very successful when we do enforce them. But why? Because what does the combined writ do for us? Well, it allows us to seize and sell the goods for the money judgment on the writ, and if payment's not made of the judgment and fees, then we can take possession of the property. So how would we do this process? Well, firstly, for the money judgment, we would issue the notice of enforcement, and if payment is not made under the notice of enforcement, we would attend the judgment debtor's premises and we would issue a notice of eviction, which would be after the expiry of the notice of enforcement. If payment's not made, then our enforcement agent would attend on the date that the judgment debt has been given for the eviction date, and we would then proceed to an eviction. However, what we do find with this process is that we very rarely actually have to evict, and actually the judgment debtors will want to enter into arrangements to pay or pay in full before that eviction date. So we have a very, very high level of success for this type of eviction and this type of writ. So it's very effective, but you need to look at the process. If you don't use the process and do it internally yourself, you may want to consider using some law firms who offer this as a service, who actually have the processes in place to be able to offer it. Where the judgment debtor owns their property, it is a very effective method of enforcement.
Okay, so that actually does conclude the webinar for today. So I want to say a massive thank you to Alan for giving up his time and actually coming and doing the webinar for us. We have had a couple of questions come in throughout the presentation. So Alan, just quickly, we've been asked, could you go over again what the trigger is for applying the stage 2 fee in the enforcement process?
The trigger for stage 2 is where there is a failure to comply on a demand for payment at stage 1. Or if we've attended at stage 1 and there's no contact, then stage 2 will apply because we will be making a further attendance.
Okay, brilliant, thank you. And someone's also asked, how do you set the payment arrangements up for judgment debtors? Is it guidelines via the company or is it via the client?
No, in terms of arrangements, we will always take the client's instructions. It may be that the judgment debtor just wants a few weeks to pay, in which case they may want to pay, say, half this week and half in a couple of weeks, in which case we will relay that back to the client, but we will take the first payment. If it's a longer term arrangement, we may ask the judgment debtor for an income and expenditure form, which we'll send to the client, but ultimately it is the client's decision whether or not the arrangement is acceptable, but we will give the client a full report on what goods the debtor has and the details of the arrangement the debtor has offered.
Okay, brilliant. The next question is, what are the compliance and enforcement stats? I think someone's asking, how do we find that a lot of people pay it compliance for it when we use high court enforcement?
What we're finding on the compliance stage is that actually the more debtors are actually paying than was forecast when the government set the enforcement stages. So it is performing a lot higher. They set it at around about 5%. We're finding it varies, but anything up to 10% are paying at compliance stage. We very rarely remove goods. It's less than 3% of all the writs that we enforce that we actually go to a removal on.
It's quite low then, 3%.
Yeah, very low. Yeah.
Okay. There is another question that's come through, but only half the questions come through. So Steve Jones, I don't know if you can just retype your question. It's not all come through, unfortunately.
No.
No, unfortunately, it's not coming through. So if anybody does have any more questions, please feel free to either type them in now in the next couple of minutes, or you're more than welcome to email myself or Alan directly and we can come back to you, or please just give either of us a bell and we can go through this for you. So thank you to everyone for staying tuned in, and hopefully we'll be in contact with you after the webinar and speak to everybody after then, and you'll be tuned into the next webinar. We'll distribute the details shortly. Thank you, everyone.